Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this Honorable Court. Be seated.
Good morning.
Good morning.
Before we call the first case, just a very brief announcement. In this docket, we will hear the 1,000th case live streaming for all three appellate courts here in the state of Tennessee since we started that process thanks to the pandemic. So it was pretty interesting to us certainly to hear the 1,000 appellate arguments have gone out available to everyone, not just in Tennessee, frankly, but everywhere else. But we, the courts, certainly owe a thanks to our IT people for making this happen. To say we weren't quite ready for that would have been an understatement. But they did a marvelous job and worked us through it and got it set up so that we could continue to keep the courts open, the appellate courts open, and open to the public to see the arguments too. And we thank them for that. Call the first case, please.
In Re Josie G.
We'll hear from the appellant.
That way you don't trip over them. If it please the court, my name is Ardina Garth-Hicks, and I am the attorney for the appellant, Rodriguez.
Could you maybe move the mic so make sure we can hear? Thank you.
And I would like to reserve 5 minutes of my time for rebuttal, if that would be possible at this time.
That'll be fine.
Your Honor, I guess continuing in the way that you may have suggested, this matter regarding Josie G basically started before the pandemic, was interrupted by the pandemic, and the termination occurred after the pandemic had somewhat subsided. And part of my argument in this case is there were so many things that were different about the pandemic that affected even the basic things that DCS did. There were shutdowns in services that people never thought would ever shut down before. People who would normally go to their med management for mental health treatment, those clinics shut down totally when the pandemic was kind of at its full swing. And my argument to the court today is that the pandemic so affected so much of the everyday life of individuals around the world, even in the state of Tennessee and in Hamilton County. But can you also imagine how differently it was for people who had mental health diagnoses, which the mother in this matter did? There were things that she would normally do and would normally show up and do, and go to have a counselor with her, go into counseling sessions with her counselor. But there were periods of time where those doors weren't even open. There were places that she could go. She had a young child. Josie was 6 weeks when she went into custody, and is now approaching 4. There were periods of time when visitation, which the department had required and helped make be in person, even make sure that it was supervised, because of the pandemic, that ended totally. There were people concerned about how visitation affected the 4-year-old or the 3-year-old at the time when they had to do things online. But people weren't asking, how was this affecting someone who may have had the diagnosis that my client had? So therefore, understanding all of the issues that were going on, and there were some things that were happening, but they were kind of reactive to what was going on. There were a lot of foster parents who had asked the department not to have in-home visitation because they were concerned about spreading the pandemic. So therefore, there were things happening during the time in which Josie was still in foster care, and her mother was not only dealing with the issues of parenting a child that was in foster care, but also with her mental health illnesses at the time.
Excuse me for interrupting.
Yes.
Counsel, in this case, how were those visits crafted and scheduled? How were they set up in terms of pandemic protocols?
They were visual, and they were call-ins, and I guess if parents had, and Ms. Rodriguez at least had Rodriguez had the ability, the mother had the ability to do online calls, but she was somewhat criticized and penalized if she didn't sit through the whole 2 hours to watch the call. The child was sometimes impatient and running around, didn't want to sit still for an hour call, and sometimes there was this criticism about the mother not developing a bond with the child because this visual, which according to what some of the studies are saying, is that there's nothing to replace in-person visits. There were issues that no accommodations were being made because of the age of the child, plus the mental diagnosis of the mother.
Were these through a platform like Zoom?
Yes.
And how many of those were scheduled?
The file is very complete. The state made a lot of, I think out of a lot of the visits that the mother had in that matter, she didn't attend all of them. There were some issues where, like I said, when she was on her medication and when she was off her medication, sometimes there were times when there were things that were being done, but they were only from the perspective of the child, not combination of the mother and the child.
You made reference to some missed visits. The record in this case would establish how many were missed?
I think when the workers did finally say it, you could say about half of them were missed.
Thank you.
So basically, Your Honor, that's my argument in all of the issues. One is that with regards to the finding of persistent condition and her mental health, it was all new territory, all new ground. There were certain things that were done. She would be asked to bring in lists of where she had been into treatment. And sometimes she didn't, where she had been going into treatment wasn't open. There was a period of time during this hearing where she actually was trying to get some treatment and ended up having to check herself into the hospital. And that was, even though she didn't totally document that with the state at the time, that was the state of affairs in some of those cases as far as if you had a mental health diagnosis, some of the things that you needed to have done. I was also kind of making the same argument when it came to make sure I got this. Dealing with it being in the best interest of the child. We did have the court, and there is a note in the record based on my brief where the court did make take notice of the fact that some of the services that the state had suggested that my client participate in were not always available during the time that they were making the recommendations. And it made it difficult sometimes to be able to complete plans and requests that were in some of the permanency plans.
Counsel, let me ask you this.
Yes.
Specifically as to the ground of mental incompetence that the trial court found, what's in the record showing that the things you've been talking about, the pandemic's effect and all that, made it difficult or impacted anything to do with that ground of mental incompetence that's in the record?
That's in the record. There's nothing really directly there other than, I guess, what you could look at, and I think that was part of my argument, is that there's a statement about her mental health. There's an issue, I think there's a report in there from a psychologist and all the, I think a parenting assessment, where they were talking about her mental health treatments. But even those matters, the doctors who saw her at those times required in-person visits. And some of those, now I think I had asked one of the doctors about that. There were certain things that in-person was necessary in order for some people in order to do their job, which was also my argument, was sometimes there needed to be an in-person visitation so that the bond that was developed and encouraged between mom and child at the time. But, Your Honor, I think that was my main thing as far as the issues, how mental health issues were somewhat treated differently. Zoom, as much as they were used in order to do some treatment and encouraged by some places, but in order to do a report based on what her mental health, I don't want to say category, what her mental health diagnosis was and what may have been treatment needed, were required to be in person. So there were some doctors, I think, that may not have participated in even providing those sorts of diagnoses or treatments because they weren't doing in-person treatments. So that would be, even though there's nothing specifically that says, based on COVID-19, this is what we saw happening, but you can read the report that the doctor did. She's in person. He did not make a choice to do it online or by Zoom. So it's stuff that's not strictly written out. This is what was done based on COVID. But when there were times when there were issues about seeing people doing things in person, I think that's what you were talking about in the court. There's certain things that are done in person that we rely on being done in person, but COVID interrupted that tremendously. And there are certain things that you take for granted, but my argument at this time is that COVID affected this case differently, and there were certain adjustments that were made, certain expectations that were there, but all of this was new as far as my client with her diagnosis and her child in foster care. Basically, if there are any questions that the court may have, I would be glad to answer them at this time.
I hear none, counsel. You have your time for a vote.
Thank you.
Thank you. We'll hear from the appellee.
Good morning, Your Honor. May it please the court. My name is Jordan Cruz. I'm with the Attorney General's office, and I'm here on behalf of the department today. The court made several findings, or 3 findings that are pertinent to this case. The first 2 are for the grounds for termination, mental incompetence, persistent conditions, as well as the child's best interest. All 3 of these findings are supported by clear and convincing evidence. And I'll first turn to the ground of mental incompetence. The mother had 2 evaluations during this case that assessed her parenting ability due to the mental issues she has. The first one was completed in the fall of 2017 by Dr. Burton Glennon. He opined that mother's mental health status rendered her incapable of caring for the child. Specifically, he said that mother's psychiatric symptoms would interfere with her ability to parent effectively, and that when off her medication, she is likely to experience psychosis, which put herself and any child she has custody of at risk. And the record is clear that she didn't keep up with her medications in this case. She herself testified she had not taken any medication in the past 9 months before trial began. And the record is also replete with instances of her not taking her medications even before that time period. And 3 years later, in September of 2020, she completed yet another parenting assessment with Mr. Benjamin Biller. This evaluation was a little different simply because the mother fell asleep a lot during this evaluation, so Mr. Biller couldn't make a complete assessment of her mental health status, but he did note her previous diagnoses of bipolar disorder, schizophrenia, and major depression. And he found it very concerning that she fell asleep during the visits, didn't complete the test that she was supposed to do. And this indicated to him that there really wasn't a lot of concern on her part for regaining custody of the child in this case. And like the previous evaluator in the fall of 2017, Mr. Biller similarly opined that mother, quote, did not demonstrate the mental ability to provide safe parenting for her children, and that her emotional characteristics pointed to significant psychopathology that would impede her ability to parent her children. He also testified at trial and reiterated those points before the trial court. And these conditions were not likely to be remedied anytime soon, simply for a few reasons. First, she didn't take her mental health medications, so she would not be able to parent her child with those unremedied mental health conditions. She also had lost her parental rights to 3 other children previously due to the same reasons. Those terminations were based, at least in part, on the mother's mental incompetence. And I'd like to stop there and go back to a question that Your Honor had asked about how COVID had affected the ground of mental incompetence. The record shows that it hadn't whatsoever. She had one mental health evaluation after the pandemic began, and that was with Mr. Biller. She arrived in person, had no problem with that. And this is something that's been going on for, over a decade at this point. Her parental rights to her 2 older children were terminated back in 2010, and the same things have kept happening for, the subsequent 12 years in this case. And that leads me to the ground of persistent conditions. This is the major issue in this case, is the mother's mental health. It's persisted for over a decade now, and this child is going to be 6 years old in November and needs permanency at this point, and she's with a family who can provide her that. She has 2 foster parents, I believe a couple foster siblings, and she is closely bonded with her foster family and her foster family's extended family. She also has significant medical needs, or at least she did at the beginning of this case. She had severe acid reflux, breathing issues, was severely developmentally delayed. She had overcome a lot of that while in the care of her foster parents. She was sleeping better at night. She was swallowing and eating better. She had responded very well to behavioral therapy. And I believe it was either the foster parent or one of the caseworkers described her progress as, quote, tremendous. So she's really doing well. This is the only family she's ever known. She was put in this house when she was an infant child. She's going to be 6 in November, like I said. She loves this family. The family loves her. And I think it's clearly in the best interest of this child to affirm the termination of the mother's parental rights so this child can at least achieve some form of stability in the near future. So if there are no further questions, I think that's it for the state.
I hear none.
Thank you.
We'll hear from the appellant rebuttal.
If it please the court, in the file, in the record that was submitted as part of the case file in this matter, please be sure to look at exhibit number 8. I brought a copy of it with me today, but it's a picture of my client, the mother, and Josie. And this was prior to the pandemic. And this was during a supervised visit, because she never had anything other than supervised visits with this child at the time. But this was something that was happening and was disrupted by the pandemic.
I'm sorry.
It was
you
disrupted.
trailed off a bit.
I'm sorry, I need to stay here. It was disrupted by the pandemic.
Thank you.
So just be sure to, it is in the file for you to look at, but it's Exhibit 8. Thank you very much.
Thank you. Court's thanks to counsel for both sides. We appreciate your oral argument this morning as well as your briefs. Thank you.